All right, we're live. Get this straightened out here. Welcome to Hat's Gorilla News. I almost said Gorilla Channel. Welcome to Hat's Gorilla News. I'm Hat, of course, and today we are going to go over the IG report, the Department of Justice IG report regarding the Hillary Clinton email scandal and the investigation of it by the FBI and the Department of Justice. So, with that said, let's get to it. Title page, Office of the Inspector General, U.S. Department of Justice. A review of various actions by the Federal Bureau of Investigation and the Department of Justice in advance of the 2016 election. Executive summary, a review of various actions by the Federal Bureau of Investigation and Department of Justice in advance of the 2016 election. Background. I have to take a drink every so often. This is Dark Magic by Green Mountain. Made it out of my Keurig. And a Yeti. Great for keeping things hot and cold. So, in response to requests from Congress, various organizations and members of the public, the Department of Justice, Office of the Inspector General, OIG, undertook this review of various actions by the Federal Bureau of Investigation, FBI, and the Department in connection with the investigation into former Secretary of State Hillary Clinton's use of a private email server. Our review included examining allegations that Department or FBI policies or procedures were not followed in connection with or in actions leading up to or related to then FBI Director James Comey's public announcement on July 5, 2016, and Comey's letters to Congress on October 28 and November 6, 2016. Allegations that certain investigative decisions were based on improper considerations. Allegations that then FBI Director Andrew McCabe should have been recused from participating in certain investigative matters. Allegations that the department's then Assistant Attorney General for Legislative Affairs, Peter Kadzik, improperly disclosed non-public information and or should have been recused from participating in certain matters. Allegations that department and FBI employees improperly disclosed non-public information during the course of the investigation, and allegations that decisions regarding the timing of the FBI's release of certain Freedom of Information FOIA documents on October 30th and November 1st, 2016, and the use of a Twitter account to publicize this release were influenced by improper considerations. During the course of the review, the OIG discovered text messages and instant messages between some FBI employees on the investigative team conducted using FBI mobile devices and computers that expressed statements of hostility toward then-candidate Donald Trump and statements of support for then-candidate Clinton. We also identified messages that expressed opinions that were critical of the conduct and quality of the investigation. We included in our review an assessment of these messages and actions by the FBI employees. Now they've done this 2 columns side by side, down, left to right, bottom to top, or top to bottom, then bottom to top. So I'm going to be scrolling up and down quite a bit. OIG methodology. The OIG reviewed significantly more than 1.2 million documents during the review and interviewed more than 100 witnesses, several on more than one occasion. These included former Director Comey, former Attorney General AG Loretta Lynch, former Deputy Attorney General DAG Sally Yates, FBI agents and supervisors, and department attorneys and supervisors who conducted the investigation, former and current members of the FBI's senior executive leadership, and former President Bill Clinton. The FBI and department referred to the investigation as Midyear exam or Midyear. The Midyear investigation was opened by the FBI in July 2015 based on a referral from the Office of the Intelligence Community Inspector General, ICIG. The investigation was staffed by prosecutors from the department's National Security Division, NSD, and the U.S. Attorney's Office for the Eastern District of Virginia, EDVA, and agents and analysts selected primarily from the FBI's Washington field office to work at FBI headquarters. I hope y'all are keeping track of all these initializations because there's a ton of them, and I've already forgotten about 90% of them. The Midyear investigation team focused on whether Clinton intended to transmit classified information on unclassified systems, knew that information included in unmarked emails was classified, or later became aware that information was classified and failed to report it. The Midyear team employed an investigative strategy that included 3 primary lines of inquiry: collection and examination of emails that traverse Clinton servers and other relevant evidence, interviews of relevant witnesses, and analysis of whether classified information was compromised by hostile cyber intrusions. As described in Chapter 5 of our report, we selected for examination particular investigative decisions that were the subject of public or internal controversy. These included the following: the preference for consent over compulsory process to obtain evidence, decisions not to obtain or seek to review certain evidence, such as the personal devices used by former Secretary Clinton's senior aides, the use of voluntary witness interviews, decisions to enter into letter use or queen for a day immunity agreements with 3 witnesses, the use of consent agreements and acts of production immunity to obtain the laptops used by Clinton's attorneys, Cheryl Mills and Heather Samuelson, to cull her personal and work-related emails, and the handling of Clinton's interview on July 2, 2016. Stepping back just a second, Cheryl Mills and Heather Samuelson were not Hillary's attorneys. They were co-workers, or actually not co-workers, they were support staff for her, but the FBI let them sit in as attorneys, and thereby giving them immunity. We'll get to that in a second. But with regard to these investigative decisions, we found, as detailed in Chapter 5, that the Midyear team sought to obtain evidence whenever possible through consent, but also used compulsory processes, including grand jury subpoenas, search warrants, and 2703D orders, court orders for non-content email information, to obtain various evidence. We found that the prosecutors provided justifications for the preference for consent that were supported by department and FBI policy and practice. Conducted voluntary witness interviews to obtain testimony, including from Clinton and her senior aides, and did not require any witnesses to testify before the grand jury. We found that one of the reasons for not using the grand jury for testimony involved concerns about exposing grand jurors to classified information. Did not seek to obtain every device, including those of Clinton's senior aides, or the contents of every email account through which a classified email may have traversed. We found that the reasons for not doing so were based on limitations the Midyear team imposed on the investigation scope, the desire to complete the investigation well before the election, and the belief that the foregone evidence was likely of limited value. We further found that those reasons were, in part, in tension with Comey's response in October 2016 to the discovery of Clinton's emails on the laptop of Anthony Weiner, the husband of Clinton's former deputy chief of staff and personal assistant, Uma Abedin. Considered but did not seek permission from the department to review certain highly classified materials that may have included information potentially relevant to the Midyear investigation. The classified appendix to this report describes in more detail the highly classified information, its potential evidence to the Midyear investigation, the FBI's reasons for not seeking access to it, and our analysis. Granted letter use immunity and or queen for a day immunity to 3 witnesses in exchange for their testimony after considering, as provided for in department policy, the value of the witness's testimony, the witness's relative culpability, and the possibility of a successful prosecution. Use consent agreements and active production immunity to obtain the culling laptops used by Mills and Samuelson, in part to avoid the uncertainty and delays of a potential motion to quash any subpoenas or search warrants. We found that these decisions were occurring at a time when Comey and the Midyear team had already concluded that there was likely no prosecutable case and believed it was unlikely the culling laptops would change the outcome of the investigation. Right. Asked Clinton what appeared to be appropriate questions and made use of documents to challenge Clinton's testimony and assess her credibility during her interview. We found that, by the date of her interview, the Midyear team and Comey had concluded that the evidence did not support criminal charges, absent a confession or false statement by Clinton during the interview, and that the interview had little effect on the outcome of the investigation, and allowed Mills and Samuelson to attend the Clinton interview as Clinton's counsel, even though they were also fact witnesses, because the Midyear team determined that the only way to exclude them was to subpoena Clinton to testify before the grand jury, an option that we found considered. We found no persuasive evidence that Mills or Samuelson's presence influenced Clinton's interview. Nevertheless, we found that the decision to allow them to attend the interview was inconsistent with typical investigative strategy. For each of these decisions, we analyzed whether there was evidence of improper considerations, including bias, and also whether the justifications offered for the decision were a pretext for proper but unstated considerations. The question we considered was not whether a particular investigative decision was the ideal choice or one that could have been handled more effectively, but whether the circumstances surrounding the decision indicated that it was based on considerations other than the merits of the investigation. If a choice made by the investigative team was among two or more reasonable alternatives, we did not find that it was improper, even if we believed that an alternative decision would have been more effective. Thus, a determination by the OIG that a decision was not unreasonable does not mean that the OIG has endorsed the decision or concluded that the decision was the most effective among the options considered. We took this approach because our role as an OIG is not to second-guess valid discretionary judgments made during the course of an investigation, and this approach is consistent with the OIG's handling of such questions in past reviews. In undertaking our analysis, our task was made significantly more difficult because of text and instant messages exchanged on FBI devices and systems by 5 FBI employees involved in the Midyear investigation. Now, we've only really heard about the 2, Strzok and Page, so this ought to be interesting. These messages reflected political opinions in support of former Secretary Clinton and against her then political appointment, Donald Trump. Some of these text messages and instant messages mixed political commentary with discussions about the Midyear investigation and raised concerns that political bias may have impacted investigative decisions. In particular, we were concerned about text messages exchanged by FBI Deputy Assistant Director Peter Strzok and Lisa Page, Special Counsel to the Deputy Director, that potentially indicated or created the appearance that investigative decisions were impacted by bias or improper considerations. As we describe in Chapter 12 of our report, most of the text messages raising such questions pertain to the Russia investigation, which was not a part of this review. Nonetheless, the suggestion in certain Russia-related text messages in August 2016 that Strzok might be willing to take official action to impact presidential candidate Trump's electoral prospects caused us to question the earlier Midyear investigative decisions into which Strzok was involved, and whether he took specific actions in the Midyear investigation based on his political views. As we described Chapter 5 of our report, we found that Strzok was not the sole decision maker for any of these specific Midyear investigative decisions we examined in that chapter. We further found evidence that in some instances, Strzok and Page advocated for more aggressive investigative measures in the Midyear investigation, such as the use of grand jury subpoenas and search warrants to obtain evidence. There were clearly tensions and disagreements in a number of important areas between Midyear agents and prosecutors. However, we did not find documentary or testimonial evidence that improper considerations, including political bias, directly affected the specific investigative decisions we reviewed in Chapter 5, or that the justifications offered for these decisions were pretextual. Nonetheless, these messages cast a cloud over the FBI's handling of the Midyear investigation and the investigation's credibility. But our review did not find evidence to connect the political views expressed in these messages to the specific investigative decisions that we reviewed. Rather, consistent with the analytic approach we described above, we found that these specific decisions were the result of discretionary judgments made during the course of an investigation by the Midyear agents and prosecutors, and that these judgment calls were not unreasonable. The broader impact of these texts and instant messages, including on such matters as the public perception of the FBI and the Midyear investigation, are discussed in Chapter 12 of our report. Comey's public statement on July 5th, Endgame discussions. As we describe in Chapter 6 of the report, by the spring of 2016, Comey and the Midyear team had determined that, absent an unexpected development, evidence to support a criminal prosecution of Clinton was lacking. Sorry about that. It was FedEx. I'd have the windows closed, but it's a really nice day outside, and the computer heats the room up. So if it gets too loud, put something in the chat, and I'll close the window. I may have to turn the fan on, though, so it'll be an either or. But let me know. Midyear team members told us that they based this assessment on a lack of evidence showing intent to place classified information on the server or knowledge that the information was classified. We described the factors that the department took into account in its decision to decline prosecution in Chapter 7 of our report and below. Comey told the OIG that as he began to realize the investigation was likely to result in a declination, he began to think of ways to credibly announce its closing. Comey engaged then DAG Yates in discussions in April 2016 about the endgame for the Midyear investigation. Comey said that he encouraged Yates to consider the most transparent options for announcing a declination. Yates told the OIG that as a result of her discussions with Comey, she thought the department and FBI would jointly announce any declination. Comey said he also told Yates that the closer they got to the political conventions, the more likely he would be to insist that a special counsel be appointed, because he did not believe the department could credibly announce the closing of the investigation once Clinton was the Democratic Party nominee. Comey, the political animal to the end. However, we did not find evidence that Comey ever seriously considered requesting a special counsel. Instead, he used the reference to a special counsel as an effort to induce the department to move more quickly to obtain the Mills and Samuelson culling laptops and to complete the investigation. Although Comey engaged with the department in these endgame discussions, he told us that he was concerned that involvement by then AG Loretta Lynch in a declination announcement would result in corrosive doubt about whether the decision was objective and impartial, because Lynch was appointed by a president from the same political party as Clinton. Comey cited other factors to us that he said caused him to be concerned by early May 2016 that Lynch could not credibly participate in announcing a declination. An alleged instruction from Lynch at Midyear at a meeting in An alleged instruction from Lynch at a meeting in September 2015 to call the Midyear investigation a quote-unquote matter in statements to the media and Congress, which we describe in Chapter 4 of our report, statements made by then President Barack Obama about the Midyear investigation, which are also discussed in Chapter 4, and concerns that certain classified information mentioning Lynch would leak, which we describe in Chapter 6 and in the classified appendix. As we discuss below and in Chapter 6 of our report, the meeting between Lynch and former President Clinton on June 27, 2016, also played a role in Comey's decision to deliver a unilateral statement. Comey did not raise any of these concerns with Lynch or Yates. Rather, unbeknownst to them, Comey began considering the possibility of an FBI-only public statement in late April and early May 2016. Wow. What was the statement again? July 5th? Comey told the OIG that a separate public statement was warranted by the 500-year flood in which the FBI found itself, and that he weighed the need to preserve the credibility and integrity of the department and FBI, and the need to protect a sense of justice more broadly in the country, that things are fair, not fixed, and they're done independently. Comey's draft statement. Comey's initial draft statement, which he shared with the FBI senior leadership on May 2nd, criticized Clinton's handling of classified information as, quote-unquote, grossly negligent, but concluded that no reasonable prosecutor would bring a case based on the facts developed in the mid-year investigation. Over the course of the next 2 months, Comey's draft statement underwent various language changes, including the following. The description of Clinton's handling of classified information was changed from grossly negligent to extremely careless. A statement that the sheer volume of information classified as secret supported an inference of gross negligence was removed and replaced with a statement that the classified information they discovered was, quote, especially concerning because all of these emails were housed on servers not supported by full-time staff, unquote. A statement that the FBI assessed that it was reasonably likely that hostile actors gained access to Clinton's private email server and was changed to possible. The statement also acknowledged that the FBI investigation and its forensic analysis did not find evidence that Clinton's email server systems were compromised, and a paragraph summarizing the factors that led the FBI to assess that it was possible that hostile actors had accessed Clinton's server was added, and at one point referenced the classified information. Comey told us that he included criticism of former Secretary Clinton's uncharged conduct because unusual transparency was necessary for an unprecedented situation, and that such transparency was the best chance we had of having the American people have confidence that the justice system works. Other witnesses told the OIG that Comey included this criticism to avoid creating the appearance that the FBI was letting Clinton off the hook, as well as to message the decision, not massage, message the decision to the FBI workforce to emphasize that employees would be disciplined for similar conduct and to distinguish the Clinton investigation from the cases of other public figures who had been prosecuted for mishandling violations. So, rules for us and rules for Hillary. The tarmac meeting and impact on Comey's statement. On June 27, 2016, Lynch met with former President Clinton on Lynch's plane, which was parked on the tarmac at a Phoenix airport. This meeting was unplanned, and Lynch's staff told the OIG they received no notice that former President Clinton planned to board Lynch's plane. Both Lynch and former President Clinton told the OIG that they did not discuss the mid-year investigation or any other department investigation during their conversation. I can't read that with a straight face. Chapter 6 of our report describes their testimony about the substance of their discussion. Lynch told the OIG that she became increasingly concerned as the meeting went on, and stated that it was just too long a conversation to have had. Following this meeting, Lynch obtained an ethics opinion from the Departmental Ethics Office that she was not required to recuse herself from the mid-year investigation, and she decided not to voluntarily recuse herself either. In making this decision, Lynch told the OIG that stepping aside would create a misimpression that she and former President Clinton had discussed inappropriate topics, or that her role in the mid-year investigation was somehow greater than it was. Okay, remember, there is the part of their oath where they say they will not create even an appearance of impropriety. On July 1st, during an interview with a reporter, Lynch stated that she was not recusing from the mid-year investigation, but that she fully expected to accept the recommendation of the career agents and prosecutors who conducted the investigation, as is the common process, quote unquote. Then, in a follow-up question, Lynch said, I'll be briefed on the findings, and I will be accepting their recommendations. Lynch's statements created considerable public confusion about the status of her continuing involvement in the Midyear investigation. Although we found no evidence that Lynch and former President Clinton discussed the Midyear investigation or engaged in other inappropriate discussion during their tarmac meeting, we also found that Lynch's failure to recognize the appearance problem created by former President Clinton's visit and to take action to cut the visit short was an error in judgment. We further concluded that her efforts to respond to the meeting by explaining what her role would be in the investigation going forward created public confusion and did not adequately address the situation. Comey told the OIG that he was 90% there, highly likely, to make a separate public statement prior to the tarmac meeting, but that the tarmac meeting, quote unquote, tipped the scales toward making his mind up to go forward with his own public statement. Comey's decision not to tell department leadership. Comey acknowledged that he made a conscious decision not to tell department leadership about his plans to make a separate statement because he was concerned that they would instruct him not to do it. He also acknowledged that he made the decision when he first conceived of the idea to do the statement, even as he continued to engage the department in discussions about the end game for the investigation. Comey admitted that he concealed his intentions from the department until the morning of his press conference on July 5th and instructed his staff to do the same to make it impracticable for department leadership to prevent him from delivering his statement. We found that it was extraordinary and insubordinate for Comey to do so, and we found none of his reasons to be a persuasive basis for deviating from well-established department policies in a way intentionally designed to avoid supervision by department leadership over his actions. Bang! On the morning of July 5th, 2016, Comey contacted Lynch and Yates about his plans to make a public statement, but did so only after the FBI had notified the press. In fact, the department first learned about Comey's press conference from a media inquiry rather than from the FBI. When Comey did not call Lynch that morning, he told her that he was not going to inform her about the substance of his planned press statement. I need to adjust something here. Excuse me just a moment. I need to have this on top. There we go. It's in my eyesight better, so I can see the health of the stream. Okay, where were we? I'll just start at the top of the page. I totally forgot where I was at. On July 1st, during an interview with a reporter, Lynch stated that she was not recusing from the Midyear investigation. Oh, no, I did read that. Okay, here we are. While Lynch asked Comey what the subject matter of the statement was going to be, Comey told her in response it would be about the Midyear investigation. She did not ask him to tell her what he intended to say about the Midyear investigation. We found that Lynch, having decided not to recuse herself, retained authority over both the final prosecution decision and the department's management of the Midyear investigation. As such, we believe she should have instructed Comey to tell her what he intended to say beforehand and should have discussed it with Comey. Comey's public statement announced that the FBI had completed its Midyear investigation, criticized Clinton and her senior aides as extremely careless in their handling of the classified information, stated that the FBI was recommending that the department decline prosecution of Clinton, and asserted that, quote, no reasonable prosecutor, unquote, would prosecute Clinton based on the facts developed by the FBI during its investigation. We determined that Comey's decision to make this statement was the result of his belief that only he had the ability to credibly and authoritatively convey the rationale for the decision to not seek charges against Clinton, and that he needed to hold the press conference to protect the FBI and the department from the extraordinary harm that he believed would have resulted had he failed to do so. While we found no evidence that Comey's statement was a result of bias or an effort to influence the election, we did not find his justifications for issuing the statement to be reasonable or persuasive. We concluded that Comey's unilateral announcement was inconsistent with department policy and violated long-standing department practice and protocol by, among other things, criticizing Clinton's uncharged conduct. We also found that Comey usurped the authority of the Attorney General and inadequately and incompletely described the legal position of department prosecutors. Now, is the left still going to stand behind Comey and say that he was a great director and that he should have been kept on, or are they finally going to turn on him? The department's declination decision on July 6th. Following Comey's public statement on July 5th, the Midyear prosecutors finalized their recommendation that the department decline prosecution of Clinton, her senior aides, and the senders of emails determined to contain classified information. I'm sorry, I got a hair. Probably cat fur. On July 6th, the Midyear prosecutors briefed Lynch, Yates, Comey, other members of department and FBI leadership, and FBI Midyear team members about the basis for the declination's recommendation. Lynch subsequently issued a short public statement that she met with the career prosecutors and agents who conducted the investigation and received and accepted their unanimous recommendation that the investigation be closed without charges. We found that the prosecutors considered 5 federal statutes: 18 U.S.C. 793D and E, willful mishandling of documents or information relating to the national defense; 18 U.S.C. 793F, removal, loss, theft, abstraction, or destruction of documents or information related to the national defense through gross negligence or failure to report such removal, loss, theft, abstraction, or destruction; 18 U.S.C. 1924, unauthorized removal and retention of classified documents or material by government employees; and 18 U.S.C. 2071, concealment, removal, or mutilation of government records. As described in Chapter 7 of our report, the prosecutors concluded that the evidence did not support prosecution under any of these statutes for various reasons, including that former Secretary Clinton and her senior aides lacked the intent to communicate classified information on unclassified systems. I'll be happy to see how they argue that. Critical to their conclusion was that the emails in question lacked proper classification markings, that the senders often refrained from using specific classified facts or terms in emails, and worded emails carefully in an attempt to talk around classified information, that the emails were sent to other government officials in furtherance of their official duties, and that former Secretary Clinton relied on the judgment of State Department employees to properly handle classified information, among other facts. So, it's not my fault because I'm not responsible. We further found that the statute that required the most complex analysis by the prosecutors was Section 793F1, the gross negligence provision that has been the focus of much of the criticism of the declination decision. As we describe in Chapters 2 and 7 of our report, the prosecutors analyzed the legislative history of Section 793F1, relevant case law, and the Department's prior interpretation of the statute. They concluded that Section 793F1 likely required a state of mind that was so gross as to almost suggest deliberate intention, criminally reckless, or something that falls just short of being willful, as well as evidence that the individuals who sent emails containing classified information knowingly included or transferred such information onto unclassified systems, which they did. Hillary had an unclassified server in her home out in New York, and they were transferring these documents, these State Department documents, onto that server. And she was not using a state.gov email address. She was using a private email address for quite some time, which Obama had and communicated with her on, as you saw previously in the document. The Midyear team concluded that such proof was lacking. We found that this interpretation of 793F1 was consistent with the Department's historical approach in prior cases under different leadership, including the 2008 decision not to prosecute former Attorney General Alberto Gonzales for mishandling classified documents. What about the sailor who took some pictures on a nuclear sub, threw the camera away without ever developing the pictures, and then went to jail for it? That sounds like a double standard to me. We analyzed the department's declination decision according to the same analytical standard that we applied to other decisions made during the investigation. We did not substitute the OIG's judgment for the judgments made by the department, but rather sought to determine whether the decision was based on improper considerations, including political bias. We found no evidence that the conclusions by the prosecutors were affected by bias or other improper considerations. Rather, we determined that they were based on the prosecutor's assessment of the facts, the law, and past department practice. We therefore concluded that these were legal and policy judgments involving core prosecutorial discretion that were for the department to make. Discovery in September 2016 of emails on the Wiener laptop. In September 2016, the FBI's New York Field Office, NYO, and the U.S. Attorney's Office for the Southern District of New York, SDNY, began investigating former Congressman Anthony Weiner for his online relationship with a minor. A federal search warrant was obtained on September 26, 2016 for Weiner's iPhone, iPad, and laptop computer. The FBI obtained these devices the same day. The search warrant authorized the government to search for evidence relating to the following crimes: transmitting obscene material to a minor, sexual exploitation of children, and activities related to child pornography. The Weiner case agent told the OIG that he began processing Weiner's devices on September 26, and that he noticed within hours that there were over 300,000 emails on the laptop. He said that either that evening or the next morning, he saw at least one BlackBerry pin message between Clinton and Abedin, as well as emails between them. He said that he recalled seeing emails associated with about 7 domains, such as yahoo.com, state.gov, clintonfoundation.org, clintonemail.com, and hillaryclinton.com. The case agent immediately notified his NYO chain of command, and the information was ultimately briefed to NYO Assistant Director in Charge, ADIC, William Sweeney, on September 28th. Reporting of emails to FBI headquarters. As we describe in Chapter 9 of our report, Sweeney took the following steps to notify FBI headquarters about the discovery of Midyear-related emails on the Weiner laptop. On September 28th, during a secure video teleconference, SVTC, Sweeney reported that Weiner investigation agents had discovered 141,000 emails on Weiner's laptop that were potentially relevant to the Midyear investigation. The OIG determined that this SVTC was led by then Deputy Director Andrew McCabe, disgraced Deputy Director, and that approximately 39 senior FBI executives likely would have participated. Comey was not present for the SVTC. Sweeney said he spoke again with McCabe on the evening of September 28th. Sweeney said that during this call, he informed McCabe that NYO personnel had continued processing the laptop and that they had now identified 347,000 emails on the laptop. Sweeney said he also called 2 FBI executive assistant directors on September 28th and informed them that the Weiner case team had discovered emails relevant to the Midyear investigation. I'll move the mic closer. I'm shouting a bit. It's going to ruin my voice. Tell me if this is bad or if it works. Sweeney also said he called 2 FBI executive assistant directors, EAD, on September 28th and informed them that the Weiner case team had discovered emails relevant to the Midyear investigation. One of the EADs told the OIG that he had then called McCabe, and that McCabe told the EAD that he was aware of the emails. The EAD told us that there was no doubt in my mind when we finished that conversation that McCabe understood the gravity of what the find was. Sweeney said he also spoke to FBI Assistant Director E.W. Bill Priestap on September 28th and 29th, 2016. Emails indicate that during their conversation on September 29th, they discussed the limited scope of the Weiner search warrant, i.e., the need to obtain additional legal process to review any Midyear-related email on the Weiner laptop. Initial response of FBI headquarters. McCabe told the OIG that he considered the information provided by Sweeney to be a big deal, and said he instructed pre-step to send a team to New York to review the emails on the Wiener laptop. McCabe told the OIG that he recalled talking to Comey about the issue right around the time McCabe found out about it. McCabe described it as a flyby, where the Wiener laptop was like one on a list of things that we discussed. Comey said that he recalled first learning about the additional emails on the Wiener laptop at some point in early October 2016, although he said it was possible this could have occurred in late September 2016. Comey told the OIG that this information, quote, didn't index, unquote, with him, which he attributed to the way the information was presented to him and the fact that I don't know that I knew that Wiener was married to Uma Abedin at the time. Text messages of FBI Deputy Assistant Director Peter Strzok indicated that he, McCabe, and pre-step discussed the Wiener laptop on September 28th. Strzok said he had initially planned to send a team to New York to review the emails, but a conference call with NYO was scheduled instead. The conference call took place on September 29th, and 5 members of the FBI Midyear team participated. Notes from the conference call indicate the participants discussed the presence of a large volume of emails, 350,000, on the Wiener laptop and specific domain names, including clintonemail.com and state.gov. The Midyear SSA said that NYO also mentioned seeing the BlackBerry domain emails on the Wiener laptop. Additional discussions took place on October 3rd and 4th, 2016. However, after October 4th, we found no evidence that anyone associated with the Midyear investigation, including the entire leadership team at FBI headquarters, took any action on the Wiener laptop issue until the week of October 24th, and then did so only after the Wiener case agent expressed concerns to the SDNY, prompting SDNY to contact the Office of the Deputy Attorney General, ODAG, on October 21st to raise concerns about the lack of action. Re-engagement of FBI headquarters. On Friday, October 21st, SDNY Deputy Assistant June Kim contacted ODAG and was put in touch with DAAG George Toscas, the most senior career department official involved in the Midyear investigation. Thereafter, at Toscas' request, one of the Midyear prosecutors called Strzok. This was the first conversation that the FBI had with Midyear prosecutors about the Wiener laptop. Toscas said he asked McCabe about the Wiener laptop on Monday, October 24th, after a routine meeting between FBI and department leadership. McCabe told us that this interaction with Toscas caused him to follow up with FBI Midyear team about the Wiener laptop and to call McCord about the issue. On October 26th, NYO, SDNY, and Midyear team members participated in a conference call. The FBI Midyear team told the OIG that they learned important new information on this call, specifically that there was a large volume of emails on the Wiener laptop, particularly the potential for a large number of clintonemails.com email, and 2, that the presence of BlackBerry data indicated that emails from Clinton's first 3 months as Secretary of State, Secretary of State, could be present on the laptop. However, as we describe above and in Chapter 9 of our report, these basic facts were known to the FBI by September 29th, 2016. So basically, virtually an entire month. And I thought they wanted to clear that up before the election. Oh wait, they did. They passed on her being prosecuted in July. The FBI Midyear team briefed McCabe about the information from the conference call on the evening of October 26, 2016. McCabe told us that he felt the situation was quote-unquote absolutely urgent and proposed the FBI Midyear team meet with Comey the following day. On October 27th at 5:20 a.m., McCabe emailed Comey stating that the Midyear team has come across some additional actions that they believe they need to take, and recommending that they meet that day to discuss the implications if you have any space on your calendar. Comey stated that he did not know what this email was about when he received it and did not initially recall that he had been previously notified about the Wiener laptop. We found that by no later than September 29th, FBI executives and the FBI Midyear team had learned virtually every fact that was cited by the FBI in late October as justification for obtaining the search warrant for the Wiener laptop, including that the laptop contained over 340,000 emails, some of which were from domains associated with Clinton, including state.gov, clintonfoundation.org, clintonemail.com, and hillaryclinton.com, numerous emails between Clinton and Abedin, an unknown number of BlackBerry communications on the laptop, including one or more messages between Clinton and Abedin, indicating the possibility that the laptop contained communications from the early months of Clinton's tenure, and emails dated beginning in 2007 and covering the entire period of Clinton's tenure as Secretary of State. As we describe in Chapter 9 of our report, the explanations we were given for the FBI's failure to take immediate action on the Wiener laptop fell into four general categories. The FBI Midyear team was waiting for additional information about the contents of the laptop from NYO, which was not provided until late October. The FBI Midyear team could not review the emails without additional legal authority, such as consent or a new search warrant. The FBI Midyear team and senior FBI officials did not believe the information on the laptop was likely to be significant, and key members of the FBI Midyear team had been reassigned to the investigation of Russian interference in the U.S. election, which was a higher priority. Russiagate. We found these explanations to be unpersuasive justifications for not acting sooner, given the FBI leadership's conclusion about the importance of the information and that the FBI Midyear team had sufficient information to take action in early October and knew at the time that it would need a new search warrant to review any Clinton-Abedin emails. Moreover, given the FBI's extensive resources, the fact that Strzok and several other FBI members of the Midyear team had been assigned to the Russia investigation, which was extremely active during the September and October time period, was not an excuse for failing to take any action during this time on the Wiener laptop. The FBI's failure to act in late September or early October is even less justifiable when contrasted with the attention and resources that FBI management and some members of the Midyear team dedicated to other activities in connection with the Midyear investigation during the same period. As detailed in Chapter 8, these activities included the preparation of Comey's speech at the FBI SAC conference on October 12th, a speech designed to help equip SACs to bat down information about the July declination decision, the preparation and distribution of detailed talking points to FBI SACs in mid-October in order, again, to equip people who are going to be talking about it anyway with the actual facts and the FBI's actual perspective on the declination, and a briefing for retired FBI agents conducted on October 21st to describe the investigative decisions made during the Midyear so as to arm former employees with facts so they too might counter quote-unquote falsehoods and exaggerations. I'll let that stand as stated. In assessing the decision to prioritize the Russia investigation over follow-up on the Midyear related investigative lead discovered on the Wiener laptop, we were particularly concerned about text messages sent by Strzok and Page that potentially indicated or created the appearance that investigative decisions they made were impacted by bias or improper considerations. Most of the text messages raising such questions pertain to the Russia investigation, and the implication in some of these text messages, particularly Strzok's August 8 text message, will stop candidate Trump from being elected, was that Strzok might be willing to take official action to impact a presidential candidate's electoral prospects. Under these circumstances, we did not have confidence that Strzok's decision to prioritize the Russia investigation over following up on the Midyear-related investigative lead discovered on the Wiener laptop was free from bias. We searched for evidence that the Wiener laptop was deliberately placed on the back burner by others in the FBI to protect Clinton, but found no evidence in emails, text messages, instant messages, or documents that suggested an improper purpose. So they didn't leave a paper trail. We also took note of the fact that numerous other FBI executives, including the approximately 39 who participated in the September 28th SVTC, were briefed on the potential existence of Midyear-related emails on the Wiener laptop. We also noted that the Russia investigation was under the supervision of Priestap, for whom we found no evidence of bias and who himself was aware of the Wiener laptop issue by September 29th. However, we also did not identify a consistent or persuasive explanation for the FBI's failure to act for almost a month after learning of the potential Midyear-related emails on the Wiener laptop. The FBI's inaction had potentially far-reaching consequences. Comey told the OIG that, had he known about the laptop in the beginning of October and thought the email review could have been completed before the election, it may have affected his decision to notify Congress. Comey told the OIG, "I don't know if it would have put us in a different place, but I would have wanted to have the opportunity." Comey's decision to notify Congress on October 28th. Following the briefing from the FBI Midyear team on October 27, 2016, Comey authorized the Midyear team to seek a search warrant, telling the OIG that the volume of emails and the presence of BlackBerry emails on the Wiener laptop were two highly significant facts. As we describe in Chapter 13 of our report, McCabe joined this meeting by phone, but was asked not to participate and subsequently recused himself from the Midyear investigation on November 1st, 2016. The issue of notifying Congress of the Wiener laptop development was first raised at the October 27th briefing, and over the course of the next 24 hours, numerous additional discussions occurred within the FBI. As we describe in Chapter 10 of our report, the factors considered during those discussions included Comey's belief that failure to disclose the existence of the emails would be an act of concealment, the belief that Comey had an obligation to update Congress because the discovery was potentially significant and made his prior testimony that the investigation was closed no longer true, an implicit assumption that Clinton would be elected president, fear that the information would leak if the FBI failed to disclose it. With McCabe hanging around, how could there be a leak? Now with Comey hanging around, I do beg your pardon. Excuse me for that. Concern that failing to disclose would result in accusations that the FBI had, quote-unquote, engineered a cover-up to help Clinton get elected. Concerns about protecting the reputation of the FBI. Concerns about the perceived illegitimacy of a Clinton presidency that would follow from a failure to disclose the discovery of the emails if they proved to be significant. Concerns about the electoral impact of any announcement, and the belief that the email review could not be completed before the election. As a result of these discussions on October 27th, Comey decided to notify Congress about the discovery of Midyear-related emails on the Wiener laptop. Comey told us that, although he believed very strongly that our rule should be we don't comment on pending investigations, and that it was a very important norm for the department to avoid taking actions that could impact an imminent election, he felt he had an obligation to update Congress because the email discovery was potentially very significant and it made his prior testimony no longer true. We found no evidence that Comey's decision to send the October 28 letter was influenced by political preferences. Instead, we found that his decision was the result of several interrelated factors that were connected to his concern that failing to send the letter would harm the FBI and his ability to lead it, and his view that candidate Clinton was going to win the presidency and that she would be perceived to be an illegitimate president if the public first learned of the information after the election. Although Comey told us that he, quote, did make this decision because he thought it would leak otherwise, unquote, several FBI officials told us that the concern about leaks played a role in the decision. Much like with his July 5th announcement, we found that in making this decision, Comey engaged in ad hoc decision-making based on his personal views even if it meant rejecting long-standing department policy or practice. We found unpersuasive Comey's explanation as to why transparency was more important than department policy and practice with regard to the reactivated mid-year investigation, while, by contrast, department policy and practice were more important to follow with regard to the Clinton Foundation and Russia investigations. Comey's description of his choice as being between two doors, one labeled Speak and one labeled Conceal, was a false dichotomy. The two doors were actually labeled Follow Policy Practice and Depart from Policy Practice. Although we acknowledge that Comey faced a difficult situation with unattractive choices, in proceeding as he did, we concluded that Comey made a serious error of judgment. Department and FBI leadership discussions. On October 27th, Comey instructed his Chief of Staff, James Rybecki, to reach out to the department about his plans to notify Congress. As we describe in Chapter 10 of our report, Comey told the OIG that he decided to ask Rybecki to inform the department rather than to contact Lynch or Yates directly because he did not, quote-unquote, want to jam them, and I wanted to offer them the opportunity to think about and decide whether they wanted to be engaged on it, unquote. Rybecki and Axelrod spoke on the afternoon of October 27th and had a series of phone calls the rest of the day. Rybecki told Axelrod that Comey believed he had an obligation to notify Congress about the laptop in order to correct a misimpression that the mid-year investigation was closed. Lynch, Yates, Axelrod, and their staffs had several discussions that same day as to whether Lynch or Yates should call Comey directly, but said they ultimately decided to have Axelrod communicate, quote-unquote, the strong view that neither the DAG nor AG felt this letter should go out. Yates told us that they were concerned that direct contact with Comey would be perceived as strong-arming him, and that based on her experience with Comey, he was likely to push back hard against input from Lynch or her, especially if accepting their input meant that he had to go back to his staff and explain that he was reversing his decision. She said that she viewed Rybecki as the person they needed to convince if they wanted to change Comey's mind. Accordingly, Axelrod informed Rybecki on October 27 of the department's strong opposition to Comey's plan to send a letter. Rybecki reported to Comey that the department recommended against the congressional notification and thought it was a bad idea. Although Comey told us that he would not have sent the letter if Lynch or Yates had told him not to do so, he said he viewed their response as only a recommendation and interpreted their lack of direct engagement as saying,